Felony DWI. What makes a DWI a felony, and what can you do about it? If you or a loved one is facing a felony DWI, what are some of the things you should be doing right now? Hi, I'm Jeff Hampton with the Hampton Law Firm. Thank you for joining us today on our YouTube channel. Today I'm going to talk to you about all things related to felony DWI. Now listen, I have a video series that speaks quite a bit about misdemeanor DWIs and first-time offenses related to DWIs, and I encourage you to go back into my YouTube channel and take a look at some of those, because today I'm going to focus more exclusively on what makes a DWI a felony. Now I'm going to just tell you this, being charged with a felony DWI is a very serious matter. The very first two things you should be doing, you're doing the first of them right now. The first thing you should be doing is researching Texas DWI law as it relates to what the state of Texas must prove beyond a reasonable doubt in order to make you a convicted felon. You're doing some of that right now by watching my YouTube video, and I applaud you for doing that. But the second thing you need to do is you need to hire an experienced and aggressive DWI lawyer that is local to your area that can absolutely get on top of this and start taking some immediate steps in order to protect your freedom in your future. Okay. Now, the first thing I want to tell you is this. One thing that felony and misdemeanor DWIs have in common is that immediately upon being arrested, you have 15 days from the date of your arrest to request an administrative license revocation hearing. In other words, that means if you do not make a license request within 15 days of the date of your arrest, your license will automatically be suspended. And on felony cases, you're talking about a pretty substantial length because of prior possible, if you've been previously charged with a felony or any type of misdemeanor DWI, you could be talking about very long suspension periods, okay? So do not miss the 15-day deadline. Now, let's talk for a few minutes. What makes a felony, what makes a DWI a felony? Well, the first way to do that is to be charged with a DWI after having previously been convicted of 2 or more misdemeanor DWIs in the past. If that were to take place, you would be looking at a third-degree felony. So this is the normal felony DWI. So it's DWI third or more is the way the law defines it. That is a third-degree felony punishable by a minimum of 2 years in prison, up to 10 years in prison, and up to a $10,000 fine, okay? Now, here's what it can also require. Being charged with a felony DWI can require you to have an ignition interlock in your vehicle. It can result in an additional driver's license suspension. It can obviously require you to have much higher insurance rates. You could end up paying surcharges to the Texas Department of Public Safety. So you're talking about thousands and thousands of dollars and restrictions that are upon your ability to drive and your freedom when you're facing a felony DWI. Now, I want to talk about one where maybe you've never been in trouble in your entire life, but now you were arrested for a DWI and you had a child passenger, maybe under the age of 15, in your vehicle. Here's the thing. If you were arrested and charged with a DWI and there was a child in the vehicle at the time of the arrest, you are now going to be charged with a state jail felony of DWI with a child passenger. And that means that the range of punishment is a minimum of 6 months or 180 days, up to 2 years in a state jail facility, and up to a $10,000 fine. Now, I'm going to just quickly go over some of the remaining examples of what can make a DWI felony, okay? Now, what if you've never been in trouble before and you are arrested for a DWI-related offense where an accident occurs, and as a result of that accident, someone it receives a serious bodily injury? Now, what does that mean, to have a serious bodily injury? That means someone has a permanent loss of use or impairment, or a protracted loss of use or impairment of a bodily member or organ. Let's say someone ends up being crippled, someone loses part of their eyesight, or they're somehow unable to use an arm or a leg or something along those lines for an extended period of time. You could be facing a third-degree felony in that situation, punishable by up to 10 years in prison and up to a $10,000 fine. So listen, all of these kind of go in line with one another. I'm just trying to let you know, people don't understand that even if it's a first-time offense for you, you could still be looking at a felony case depending upon how the DWI turns out and what the facts of your case were, okay? And then everyone knows the intoxication manslaughter. That's a situation where even if it's a first-time offense, someone is driving while intoxicated, and as a result of that driving while intoxicated, someone dies as a result of that DWI. There you'd be looking at a second-degree felony punishable by up to 20 years in prison and up to a $10,000 fine. Now, here's the key with both intoxication assault and intoxication manslaughter. The big issue that the state of Texas really has to go after on this, and sometimes it's not always as easy to prove as someone might think, the state of Texas must prove beyond a reasonable doubt that the actual intoxication was the cause of the death. Okay, so the causation element must be directly linked to someone being intoxicated. We've actually seen cases where you'll actually have experts, traffic and accident experts, that'll get up and say, this was unavoidable. Due to the circumstances of what was going to happen, it wouldn't have mattered whether they were intoxicated or not. This accident would have happened, and likely the result would have been the same. Or maybe there was a superseding or intervening cause, something that what someone else was contributorily involved in that causation, that can affect the state of Texas's ability to prove that crime beyond a reasonable doubt, okay? Now, what has to be proven on a felony DWI in court? That's a good question. What are the elements that have to be proven? Every single felony DWI must prove these particular elements. So the state of Texas must prove that you operated a motor vehicle while in a public place while intoxicated. They must prove that. Now, if you were not operating a motor vehicle, you cannot be charged with a felony DWI. There may be other crimes that would be appropriate for your set of circumstances, but if you weren't operating the motor vehicle, it may be a public intoxication, which is a Class C ticket, but you must actually be operating that vehicle. So what does it mean to operate? That's the question that comes up. To operate the vehicle does not require you to be driving the vehicle. If you are technically in the control of the vehicle and the vehicle is running, there is a chance the police could try to argue that you were in fact operating the vehicle. But I'm going to tell you, it's kind of a fine line. There are some cases out there that would establish that sleeping off intoxication in a car with the air conditioning running, but in park, that may not be operating. But falling asleep in a drive-through while your car is in drive and you're waiting and you're not moving, but you're holding up the drive-through line at a Whataburger, yeah, sorry, I've seen that one too many times. That technically is operating a motor vehicle under the law. It doesn't mean the car has to have actually been moving, okay? Just want to make sure we're clear about that. So this type of situation comes up all the time when people ask about this, whether or not it matters if you were driving or not. Now, they do have to put you behind the wheel. What if you're not in the car at the time that the police arrive? What if there is you and someone else who was in the car and the police can't identify who was actually driving the vehicle? That's a problem. The state of Texas may not be able to charge you with felony DWI. Now, what does it mean to operate a vehicle in a public place? It's another good question. What identifies as a public place? Well, a public place under Texas law is defined as a place that the public or a substantial portion of the public has access to. This includes apartment complex, parking lots, parks, hospitals. The real question is this: were you driving on private property that a substantial portion of the public would have access to? If not, if you're out in the middle of a field somewhere and you're out mudding in a car and you're drunk, there's a good chance they're not going to be able to bring a charge against you for having operated a motor vehicle in a public place. But if you're in an apartment complex parking lot, if you're in an area, even though that might be deemed as private property, but yet the public can obtain access to it, it's going to be more difficult to try to argue it's not a public place. Okay, now what does it mean to be intoxicated? Very quickly, let's identify what it means to be intoxicated. For DWI purposes, for a felony DWI, the state of Texas must prove that you did not either, number one, have the normal use of your mental faculties by reason of the introduction of alcohol or drugs. Number two, that you did not have the normal use of your physical faculties by reason of the introduction of alcohol or drugs into your body. Or number three, that you had a blood alcohol concentration of 0.08 or higher at the time of driving. So how do the police determine whether or not you had the normal use of your mental or physical faculties? Well, almost every time they're going to offer you, and they will do this every single time on a felony DWI, they're going to offer you standardized field sobriety test. Now, I'm not going to go over these in detail, but the first one's called horizontal gaze nystagmus. It's the pen test. where they're making you follow the pen. The second one is the walk and turn test. You walk down 9 steps, execute a 3-point turn and walk back, and then heel to toe, counting out loud as you do so. And then there's the number 3 is the one-leg stand. The one-leg stand is you hold up, hands down by your side. You have to look down at your foot, hold up your foot for 30 seconds, counting out loud until the officer tells you to stop. Now, these are known as divided attention tests. What the officer is trying to get you to do is to do something both mental and physical at the same time. The problem is, if you're nervous, nervousness can look a lot like intoxication because you're not thinking clearly. And if you're performing on the side of the road and people are just driving by you and you're scared to death, it's not always indicative of whether or not you're intoxicated. Okay, there can be many other reasons why someone would fail these tests. And here's the other problem. If the police don't administer these tests properly, they've been deemed to be unreliable by the National Highway Traffic and Safety Administration. So your felony DWI attorney must go over these in detail because your future and your freedom hang in the balance on this. It's important to review it. Okay. Now, how did the police determine your blood alcohol level? Well, the first thing they're going to do is they're going to ask for a sample of it. If you consent, they're going to take a sample of your blood very quickly, okay? And it's almost always blood samples whenever you're talking about felony DWIs. But if you do not consent, they're going to go get a search warrant. Now, that's not necessarily a bad thing because here's the thing. Many times it can take multiple hours for them to get a search warrant, or they may have a hard time being able to obtain a warrant, particularly if you're not intoxicated, okay? And so as a result of that, they're going to do one of two things, either consent or they're going to get a search warrant. And once they receive that, they're going to want to get that blood result back, and then they're going to want to try to claim whatever that result is proof positive that you were intoxicated at the time of driving. But here's the problem. Most of the time, you're talking about several hours later when the blood draw took place. The time frame for when you were driving to the time frame they take the blood is not the same. All the blood test proves is what level you were at the time you took the test. If someone were to take 3 shots of tequila right now, they'd smell like they're drunk. But your body has to absorb alcohol on a bell curve. So essentially, it's at 0.02 an hour. Okay, this is important. So the more time there is between when you were driving and the time that the test is given, the less reliable the test is. For instance, if a test was given 3 hours later, your blood alcohol level could be as high as 0.06 higher or 0.06 lower because of the ability for your body to metabolize at 0.02 an hour. You understand how it's just not as simple as saying whatever the blood is what you are? That's not necessarily true, okay? Finally, one of the last questions I always receive is people say, well, will my DWI third be a misdemeanor if my previous DWIs were probations? Did I have to actually go to jail? And the answer to that is no. Actually, back in 2010, the law changed on this in Gonzales v. State, where you didn't have to actually go to jail. In fact, even if your prior DWI convictions were served and you completed successfully your probation, the law will still treat your DWI probations as convictions sufficient to enhance your DWI to a third-degree felony, okay? Now, the last question people ask me is it possible to get probation for a felony DWI? Yes, it is, but I'm going to be frank with you, it's not easy. Okay? And one of the reasons I want you to understand that is it doesn't mean it's always guaranteed, but a felony DWI probation is very stringent. They're going to require you to be on a probationary term for up to 10 years. You could be required to spend a minimum of 10 days in jail. Many times, a lot of prosecutors, especially in smaller counties in Texas, want to try to make you spend anywhere between 90 to 120 days in jail as a condition of your probation. And additionally, they're going to want you to take drug and alcohol rehabilitation. They're going to want you to have an interlock device on your vehicle for the term of the probation. You're going to have court costs, all these classes that you have to take. And I will tell you, the success rate on felony DWI probations is not that great. That's why it's important that you hire the very best felony DWI attorney that you can in order to help protect you in your situation. Now listen, I would give you a free ebook, The Ultimate Guide to Your DWI Defense. in Texas. All you have to do is click the link down below. I'll be happy to email that over to you. And if you or a loved one are facing a felony DWI in the North Texas, maybe the Dallas-Fort Worth area, we would be happy to give you a free case analysis and consultation. This number that you've seen above on the screen the entire time I've been talking is our contact information, and I want to encourage you to give us a call. Maybe we can be of assistance to you. Either way, I hope you take action on this information you've heard today, and I want to thank you for joining us on our YouTube channel. We'll see you next time.